Hello there. My name's Jonathan Golding, and I'm going to speak to you today about tax avoidance. My seminar will going to concentrate on UK tax avoidance and asking the question, does the UK encourage tax avoidance? On the face of it, you probably say no, because we have plenty of anti-avoidance legislation in place. We have DOTAS, disclosure of tax avoidance schemes. We have POTUS, promoters of tax avoidance schemes. We have TIEA, tax information exchange agreements, with many countries throughout the world, including many of our ex-colony tax havens. And of course, we've got GAR. Now, you'll be familiar with GAR, the General Anti-Avoidance Rule. But in the UK, we call it the General Anti-Abuse Rule. Difference there between abuse and avoidance? Well, we consider the abuse word is more forensic than avoidance. We have a GAR panel comprised of 7 members, and they review any schemes that come before them. And they have to apply a double reasonableness test to the scheme itself. Once they've decided whether it is abuse or not abuse, they will make a decision. And then it is up to HM Revenue and Taxes to take it further if they want to. So we have plenty of anti-avoidance legislation, as I've said. So when did tax avoidance and tax evasion first come about? Well, tax avoidance, we know, is legal, and tax evasion is illegal. So we've got now in the UK acceptable tax avoidance and unacceptable tax avoidance. Now, what is acceptable tax avoidance? Well, it's very difficult to say. After reviewing the DOTAS, disclosure of tax avoidance schemes, and promoters of tax avoidance schemes, you get a decision as to whether it is acceptable or unacceptable. Now, I'm going to give you 2 cases now, and they concern a very wealthy family in the UK you may have heard of, the Duke of Westminster's. And what they've got is 2 substantial cases that have come before the courts, which is acceptable avoidance at the time. One considers whether it would be acceptable now. I'll leave it to you to make that decision. The first case was the Duke of Westminster, who employed his gardener, and he paid him a wage, and he was going to offset the wage against his other substantial income. He wasn't able to. Those were the rules at the time. So he contacted his solicitors in London, and they stated, well, why don't you do a deed of covenant? Deed of covenant is a yearly payment to the gardener. It is exactly for the same amount of income, so he won't be put out in any way, and that is allowable deduction against the other income that you receive. This is what they did, but the revenue at the time got very upset about this and took him to court. The judge came down in favour of the Duke of Westminster, saying that a person is entitled to organise their personal affairs and tax affairs such that they pay the least amount of tax that they have to legally, which is what the Duke of Westminster had done. So that was acceptable avoidance at the time. We move on to the 4th Duke of Westminster, and he was injured during the Second World War in 1945. A shell exploded near him in France, and he received shrapnel to his leg. Now, this was embedded in his leg and was there for many, many years. And then in 1967, he died of cancer. Now, his executor, Barty King, so this case is Barty King versus the Ministry of Defence. Barty King went to the Ministry of Defence and said, look, he's died. Yes, it is of cancer, but a contributory factor was this shrapnel in his leg. And they said no. And this went to the Ministry of Defence many times until eventually it went to court. And there is a rule in the UK that if you die as a result of injuries incurred in any war defending your country, all your estate will be exempt. At the moment, inheritance tax on people's estate is 40%, so a large sum. There is a small derisory exemption of 325,000. And so they pursued this with the Ministry of Defence, and they still wouldn't budge. So what they did was they went to court again, and Lord Clyde came down in favour of the Duke of Westminster and said that whilst, yes, there was many, many years between the shrapnel wound and also his dying, i.e. 1945 to 1967, that shrapnel wound was a contributory factor to the cancer because it reduced his immune system over the years, and therefore could be said to be as a result of a shrapnel wound in the Second World War. So the whole of the estate of the Duke of Westminster was exempt at that stage from inheritance tax, or it was estate duty at that time, but as I've said, it is inheritance tax now. So what they did then was they transferred this exempt estate into a trust. And today, the Dukes of Westminster, their estate is about 11 billion. And this went into the trust, and therefore there is no inheritance tax to pay any longer. The case study that I'm going to talk to you about is more or less similar to this. That is, property in the UK and worldwide can be exempt from inheritance tax if the right avoidance is taken. Right, I'm going to move on now to non-residents and non-DOMs. Monaco and London, what's the difference between those two? Well, nothing. They are full of people, foreigners, who are avoiding tax legally. Somerset Maugham said of Monaco, that is a sunny place for shady people. Well, I'd say London is a shady place for moneyed people. London is full of very wealthy Russians and Chinese and Malaysians, all who have large houses in London. Why are they there? Well, of course, it is for the tax avoidance. We go back as far back as 1799, when income tax was introduced by the William Pitt, who was the Prime Minister at the time, to pay for the Napoleonic Wars. The tax was only 10%, and this amount was collected through the populace over a certain yearly income of 60,000. They expected to get 11 million pounds, and in fact what they got was 6 million. So the difference, it was of course avoidance. As early as 1799 people were avoiding tax, and it was only a 10% rate. So it does make you wonder whether having a tax rate even as low as 10% is going to avoid the avoidance. So at the time, we had overseas possessions that would have their income brought to the UK, and the William Pitt said, well, at this stage, I don't think we can actually tax people on the income unless they bring it back to the UK from those overseas possessions. And this is when the remittance basis was first born. After that, the remittance basis stayed, and in 1914 Act, what they did was they abolished the remittance basis, but it stayed for non-DOMs, that's non-domiciled people who are resident in the UK, and also UK citizens who are resident abroad, but ordinarily resident in the UK. So the remittance basis was introduced, and this stayed until let's see, well, actually, I'll mention that intervening period, Margaret Thatcher's Chancellor decided that he would get rid of the non-dom status, and there were many ship owners, Greek ship owners living in London at the time, and they kicked up a fuss about this. So Margaret Thatcher thought it was probably best to put this on the back burner. So the remittance basis still stayed, and it is with us today, and it's a tax avoidance scheme for non-doms. Currently, at the moment, a non-dom comes to the UK, resides there. For the first 7 years of residence, there will be no tax to pay. And then for 7 years, after 7 years, they can pay an amount of £30,000 a year to keep the remittance basis applying to them. Then after 12 years, they pay £60,000 a year to keep the remittance basis. And then after 15 years, something very interesting happens. They are considered deemed domicile in the UK, which means their UK assets, as well as their worldwide assets, are all subject to inheritance tax. You may recall that that was the 40% I advised you of. So that's a substantial amount. So what should they do when the 15 years is coming up? Well, they should either leave the UK and go abroad for 6 or more years, and then they can return to the UK and they will have lost any threat of deemed domicile status for another 15 years. Alternatively, they can put their assets into exempt trusts, etc., just like the Duke of Westminster did, and they can apply this to their assets in the UK. So what we'll do now is we'll look at the case study. The case study I'm going to cover is regarding Charles Claw, and he is a person who has been very successful in the UK. He is born and bred in the UK, and after he set up a business, which was very successful, he bought assets throughout the world and also in the UK. But his planning has been such that when he moved to the Bahamas, these assets will be totally exempt from income tax and also from inheritance tax. So we'll move on to that now. So I'll see you in part 2, and that is the case study.